Building a multi-million-dollar infrastructure project is loud, messy, and physical. But the fate of that work is often decided in a place that is exactly the opposite, a completely sterile, unforgiving courtroom. If you remember the Sinisa case from Part 1, the contractor did the heavy lifting. They navigated delays that were completely out of their control, finished the project, and handed the government a bill for 11.9 million ringgit in loss and expense claims. But they made a critical paperwork error. The contract required them to file their claim notice within 30 days of the actual event that caused the delay. Instead, as this table shows, they waited until after they secured their extension of time certificates. To the contractor, it felt like a minor administrative lag. But look at the final column here. Legally, they were 25, 20, 18, and 30 days late. Because of that timing error, the High Court disallowed the entire 11.9 million ringgit claim. When the chaotic reality of a construction site collides with the rigid procedure of a legal contract, the contract acts as an absolute barrier. The contractor didn't give up without a fight. Their legal team argued the word shall in the contract's notice requirement was just a guideline, a directory suggestion rather than a mandatory rule. Their logic makes a certain kind of practical sense. When a project manager is hit with sudden variation orders on site, their priority is getting the physical work done, not rushing to file paperwork. The court rejected that logic. Clause 44.3 states if notice isn't given, the government is discharged from liability. The judge interpreted shall as an uncompromising requirement. This is a condition precedent, a mandatory hurdle to clear before claiming a single ringgit. In commercial law, these contractual words are absolute. If you don't file the notice, you forfeit the right to the money entirely. Running out of options, the contractor tried a different angle: fairness. They claimed the strict deadline violated Section 29 of the Contracts Act 1950 by restricting their right to enforce the contract. They argued the government was getting all that delayed variation work for free, leaving the employer unjustly enriched at the contractor's expense. The judge's response was blunt. We can see it right here in paragraph 109. Sinisa isn't a vulnerable consumer taking out a bank loan. They are a massive corporation handling a 157 million ringgit government infrastructure project. The court expects sophisticated businesses to act like sophisticated businesses. The contractor had the freedom to negotiate the terms, refuse the tender entirely, or simply manage their paperwork properly. The legal system exists to enforce the agreements made between capable entities. It does not exist to rescue large corporations from the financial consequences of their own poor project management. But the judge didn't walk away completely merciless. In a surprising twist, the court actually awarded the contractor 2.9 million ringgit. This specific portion was approved because it covered reasonably contemplated expenses. These are the expected, recurring overhead costs, like preliminary site operations, that happen during any extended delay. Because they were expected, they didn't trigger the strict 30-day notice requirement. This chart illustrates how the court split the claim. The 2.9 million in expected costs was approved, but the remaining 9 million ringgit represented entirely unforeseen, unbudgeted losses, and those legally required strict prior notice. This split decision proves the High Court actually understood the practical, everyday realities of construction delays and allowed recovery for obvious expenses. The law will protect a contractor's standard overhead, but it aggressively guards the legal boundaries around unknown, escalating costs. So why is the court so fiercely protective of a simple 30-day administrative deadline? You have to look at the commercial reality from the employer's side. The government relies on timely notices to accurately control massive, taxpayer-funded infrastructure budgets. If contractors don't follow the timeline, the employer gets hit with huge, surprise invoices months after the project is finished. By then, it is entirely too late for the employer to scale down the design or modify the project to keep costs under control. When we weigh practical reality against legal rigidity, this precedent declares a definitive winner. In modern infrastructure today, managing the contract is just as critical to your survival as pouring the concrete. No amount of hard work on the site will save your bottom line if you miss the rigid deadlines of the law.